And welcome to our webinar on managing new communities. My name is Mindy Knutson, and I'm the Executive Director for the Utah chapter of CAI. And we're glad you're here for this presentation this morning. And we've got some great information for you. And before we get started, we're going to welcome you. And we'd like to tell you about some of our upcoming events. CAI National has a live webinar on May 26th. It's on building consensus, and that offers strategies to reduce conflict in our communities. And that will be available on CAI National's website, caionline.org. And there's also a link to register for that here, if you'd like to look at that here. August 18th through 21st will be the National CAI Conference in Vegas, and August 25th will be our local Utah chapter, our local golf tournament. We look forward to that every year at South Mountain. So if you want to register for any chapter events or view CAI national events, check out our chapter website, and you can register for events on there. It's uccai.net. You can also, of course, view any of our past webinars that we've had that are great on our same chapter website. It's under our resource tab. Our webinar library is under our resource tab. And we also have some great sponsors. We encourage you to watch for handouts after this presentation from our platinum sponsors, who are Century West Insurance and Candace Brewster Insurance. They will be coming up after the presentation and will be included in the slide presentation that we will send to attendees. And for now, let's introduce our topic and know that during the presentation, if you have any questions for the panelists, please type them on the questions feature on your screen. Our moderator, Andrew Blomquist, will be watching for those questions, and we'll be posing them to the speakers between each speaker and kind of throughout. And then at the very end, of course, we'll call for some final questions. And if you have a final question, please just quickly type yes when we ask for final questions, so we will know not to cut you off as you're trying to type your question. So type yes, and then you'll have a little extra time to type your question, and then we'll move on. And with that, we'll turn the time over to Andrew to introduce our speakers.
Okay, Bert Willie is a shareholder with Smith Knowles, where he practices real property law, focusing primarily on community association law and representing boards and associations in all aspects of homeowner association operations across multiple states. Bert is an active member of the Utah chapter of CAI and a founding board member of the Idaho chapter, and has served in a variety of capacities with both the Idaho and Utah chapters. Bert enjoys assisting homeowner associations in successfully navigating the various legalities they face on a day-to-day basis. Scott Welker is the managing partner for the Utah offices of Weil Fotheringham. He has far-reaching experience in property law with an extended knowledge and understanding of community association law and foreclosure law. He's licensed in Arizona and Utah, where his primary practice focuses on representation of community associations, offering general counsel, litigation defense, drafting and interpretation of governing documents, and covenant enforcement. He also practices in collections and general real estate, where his experience includes quieting title, resolving boundary disputes, and drafting and defending easements. He's a member of the CAI's Legislative Action Committee, which is a body that drafts and advocates for community association legislation. The time's now yours, Bert.
Okay, thank you, Andrew, and it's good to be here. A lot of you know me. A few of you have maybe seen me a little bit less. I've kind of gotten drafted into helping Idaho kind of get off the ground the last couple of years with their chapter. So I've been tasked up there a little bit more, but that should be kind of changing, and look forward to spending a little more time here with the Utah chapter. Probably like you, a lot of mixed feelings with all the online webinar. It's really nice and convenient, but I do miss the interaction with our group here. That's probably like many of you, one of my favorite things about this area law. It can be stressful and aggravating, but the interaction with other attorneys, managers, other professionals in the industry is kind of what I enjoy most. And so at this time, I was talking with Scott as well, and it seems like a relevant time. A lot of managers get contacted about new communities and some of the issues that kind of come up with that in development. My background, it seems like attorneys come to the HOA world in a variety of different ways. I actually came from the developer side, originally doing kind of some developer work in the mid 2000s, and then that kind of led me to the HOAs. And I know some come in the opposite way as well. And so hopefully as we go through here, Andrew will be watching, but we welcome a handful of questions, both Scott and I, as we go through to kind of maybe hit on some things that you want. Obviously, this is going to be geared towards managers and kind of their interaction with developers. I view managers a little bit as kind of the gatekeepers sometimes with development. Obviously, we want good development. It's good for the industry. It's good for the practice areas. We want good communities, right, and good development. And a lot of times managers are the first contact for developers, particularly if they're less sophisticated or smaller developers. They often come to the manager first. And so one of my goals or objectives in doing this is really just helping managers maybe issue spot some of these issues. This won't be a construction defect focus, but more of operational focus with developers setting up communities to succeed and some of those issues that we often see. Okay, so yeah, kind of these three categories. So claims happen, right? And I'm going to talk a little bit about the setup and operations, some of those compliance common things that we see, representations on plats, particularly where Scott and I will probably both touch on that, and then some of this fiduciary duty, which can be a bit of a tightrope for boards and managers as communities are getting off the ground and developers or developers personnel are filling a lot of those roles. It can be a little bit interesting for them. So of course, everyone probably on this call is pretty familiar with the basic governing documents. And so one of the things that particularly I want to call the attention to is plats. And so as managers are out there working with developers and new communities, if we can get, as attorneys, if we can sit down with developers in that plat stage, we can often identify a number of different issues that will come about. Common areas, limited common areas, party walls, all those things. In fact, I just sat down with a developer last night, which is an unsophisticated developer, small developer doing stuff, and of course coming to us after the fact, which is always more problematic. But just missed, basic things in the plat that are now causing headaches. Maybe being real specific on some common area that they didn't really intend to do, and kind of creating some issues there. So if we can kind of, as an industry, help developers get set up the correct way as they're going through these documents, and particularly with the highlight kind of on the plat today, and Scott will touch on some declaration specifics. The bylaws also, don't be afraid as managers to speak up in that bylaw process. That should cater to how you like to help them run the communities, to call the meetings, hit the quorum numbers, do all those things that you want to do. As we see that continuing changing demographic in Utah, more and more people are moving in from states that have more sophisticated laws, more oversight, and they're increasing their expectation of the operations and what's happening, why a developer is in control of those operations. Okay. Oh, and then just a little side note on the rules. Help developers, advise them, keep those things in the rules that change, right? Parking, animals, certain common area maintenance, right? Whether it be pools or things like that, where we see a lot of developers sometimes put too much detail in the declaration, which maybe sounds counterintuitive to some of us out there, but those things that do kind of mold as the community progresses, if they have those within rules, it's usually much easier operationally. So setup. What's kind of required? We're going to talk about a couple of baselines here. So some of this is maybe old news to you. Maybe some is a little bit new, and hopefully you have some opportunity to ask some questions as we go through here. But Utah Department of Commerce. So that is the articles of incorporation that you think about when you set up this nonprofit corporation. And so developers are often asking managers, hey, what are the basic steps to get this thing off and running? And so we would recommend that they incorporate as a nonprofit corporation. And I'll talk about a couple of reasons why in the next slide. HOA registry is commonly missed, as many of you know. So it's actually two separate locations, right? We have the actual entity existence within the Department of Commerce, and then this HOA registry, and that can bite them a little bit down the road when they have some collection issues or issues with owners, and they'll kind of use that as arguments of poor management or poor setup. So don't forget the HOA registry. Then if they are a nonprofit corporation, that EIN number that you need to set up bank accounts. And obviously you can set up a number of different bank accounts, but if we get those at least two basics of the operating account for the HOA and the reserve account. And as you're looking at insurance and budget, one thing to keep in mind that we run into a lot is if it is a condo project or where they're seeking FHA certification on the project, it seems like 8 times out of 10 we're running into insurance issues in that process of maybe the developer not initially thinking, what's this project going to be? Are we going to want to certify it? And what are some of the insurance that we want in place? And then the same with the budget issues. Are we setting out an accurate budget from the beginning? Again, I'll touch on this as well, but one thing I do see quite a bit is you as managers don't get bullied by the developer in maybe stepping outside of your expertise. Don't be giving them insurance information. Don't kind of let them push you to draft different legal documents. So we do see managers once in a while kind of stick their neck out there. They're probably not even getting paid for it, but end up kind of creating some issues later. So you're there to also kind of remind them of what the manager's roles are, and here's a variety of professionals that can kind of help them get where they need to go. And then if you are helping with budgets, as most of you know, the Community Association Act and Condo Act will exempt a developer from some of this reserve study stuff during the control period. What we always question with developers is we say, yes, we understand you're exempt, but if you don't do some sort of study, even if it's maybe not to the extent that some are done, how are you going to set any kind of budget? So as you're kind of asked those questions, if you are helping them set the budget, make sure that you've got that background to help them do it. Otherwise, again, refer them to that third party so you're not carrying that liability. And then another common thing that we see in setup is reinvestment fees, of forgetting to record that separate notice. And we've also seen that cause a variety of issues as you get down the road, maybe a few years, and then you get an owner that comes in and says, hey, I'm not paying this, and then challenges years of reinvestment fees. So that can kind of come and bite the HOA if they're not looking at that. So that was just kind of a handful of things that we run into often in helping communities in that getting set up properly.
Hey, Bert, I'm going to actually just put just one comment on that too, on the setup side. Often the incorporation and particularly the articles of incorporation that are drafted, I think get kind of glossed over, like that's not a very important piece. Let's just kind of get that out of the way. But actually under Utah law, the articles are really important. They trump the bylaws if there's a conflict between the two. And there's some provisions that need to be in the articles. Like for instance, a lot of times declarant controlled communities, they don't really have a board. The declarant just kind of calls all the shots. That's allowed in Utah, but what the law actually says on that is that your articles have to provide for that. The articles say that you can delegate that board responsibility to a single entity or a single party, but it has to be in the article. So there's items like that I think that developers and managers working with developers need to be aware that the articles need to be done right. That's not something we should just sort of see as sort of like a quick process to just kind of gloss over.
No, Scott, that's a great point. Jumping in, and I don't know about you, but I rarely see that kind of detail in the articles, right? They're usually not taking those steps to allow them to operate maybe in the way they want to do. And it's also a good point that we often forget is the bylaws, or that the articles actually trump the bylaws. And I think that's something we forget a lot as well.
Yeah, I know for me personally, my articles that I write for developer community are different than articles that I'd write for a post turnover community, and so there are some details that should be paid attention to.
Right. Awesome. So a couple of those things with incorporation, a couple things that we often miss is, a board of directors is actually required. And so you often hear the phrase as we're going out there is, oh, the developer's the board, and the developer can have a variety of special rights and powers and appointments. And yes, that's often filled with maybe a relative of the developer, or if the developer's a bigger, company, it's employees. And so that's all fine, but helping them, remind them to actually take the step of appointing and putting those people in place, which again, as you'll see down there a little bit, is natural persons. We also run into that where developers try to set up entities to be the board. As Scott said, you can take measures to delegate certain responsibilities, to individuals, managers, things like that. But as we're setting up that board, make sure that we're setting them up as natural persons, people, and that we have that 3 minimum of directors. So that's just something we sometimes miss in that setup process. So again, being incorporated, we do have those indemnity provisions. If they're ever missing some of those within their own governing documents, we've got those within the Nonprofit Act. We do have the fallback provision, so if those articles, bylaws are missing some instruction, we can fall back to the nonprofit code and get some direction. And then it just seems like, and I know there's case law out there to the contrary, but it seems like anytime the association then is in a legal action or collection action, if they're not incorporated, you're almost always fighting that battle of, can they bring the action, can they proceed? And so anyway, if there's questions on that, but we just find with all that put together that incorporated is better than not incorporated. Okay, so I'm going to talk about a couple of these things, a little bit of an overview, and Scott's going to talk about some more. But again, board authority. So there are a number of things, and kind of what you think about it. The board acts for the association, and so that's kind of one of the keys I want you to take away as you're working with developers is, yes, developers can appoint and remove and place people in there, but there are a set number of maybe special rights that are given a declarant developer within the declaration. Maybe they can annex, directly. Maybe they can amend. They maybe can do a number of things. But if they're just doing association business, that should be functioning through the board or whoever the board is, delegating that responsibility to. And so to try to help developers establish that line of, yes, we get it, this is the initial part of the project and you're a developer, but we need to actually function as an association as well. And then a couple of common things that developers will often do. As most of you know, the Condo Act and the Community Association Act, it seems like each year are kind of marching closer together and getting more and more alike. There are still a few key differences. And one of those key differences comes in the declarant control period, where the Condo Act kind of has some automatic turnover time periods. A PUD, a planned unit development, single family home, townhome, they can often hang on to it longer. And so that's something also that I often see developers mix those concepts back and forth between a condo. Maybe they're a single family home and they're pulling in condo arbitrary turnover provisions, or they're mixing up ownership. Oftentimes you think of it as, in the planned unit development setting, association owns the common areas and all the members or all the owners are a member in that association. In the condo, you have that undivided interest in common areas. So sometimes they're mixing up those concepts as well. So board authority, as we mentioned and as Scott mentioned, the board is the one that acts for the association. So declarants, if they have a special way of operating, they can deal with that through articles, other governing documents. But certainly the default is this is how it's going to work. And we need 3 board members, whether they're developer employees or not. And then they have to use this business judgment rule. They owe fiduciary duties. And this is where you'll probably often be asking this question, and we do as well, where developers are walking that tightrope, right? Where they are on the board, they have a responsibility to act for the association, and they're also developing the project. And so one of those common push and pull that we get is we'll get concepts like bulk rate contracts, where a developer is saying, hey, I want stream of income here. I want to be able to earn this moving forward. I want to be able to enter into these bulk contracts for the association, and which it was probably a whole separate education event, and there's some different FTC rulings and different things with regard to that. But as an example, what I always push back with developers is, okay, how does this benefit the association? So as long as they're, at a minimum getting a better price, right? So what I wouldn't want to see is developers saying, hey, as the association board, I'm going to enter into this contract for this bulk rate, and it's actually going to, cost the homeowners association more than if they didn't have the bulk rate. So some of those opportunities I think we have to push back and remind developers a little bit of that win-win scenario when they're acting on the board, that they still have a responsibility to look out for the benefit of the association and not just in their development role all the time. Okay, effective communications, again, with the focus on this control period. I've seen a trend, certainly maybe Scott has as well, of developers actually wanting to get owners involved earlier on the boards and not being quite so afraid of that like they used to be. I think as long as developers, if they've got the concern of they can appoint and remove, it's nice to see those owners get on board earlier. I've seen the communications improve, the required meetings improve, and developers have generally been happier as these owners are living there taking care of the issues. And then, of course, if it comes to architectural things, you can still have separate committees and boards to help function those. And so I would encourage developers to kind of consider that. And again, kind of the frequency of communications is, let's get communications out to the community during the control period. Newsletters, information is not just all for post control period, but let us know so that hopefully if there are issues, a developer knows along the way and can kind of deal with some of those prior to just the turnover. Okay. Let's see, it went the wrong way here. Okay, so my last one here, and then we'll kick it over to Scott and maybe a little back and forth as well. So again, my takeaway on these first 20 minutes of slides is, again, the role of the manager and kind of the gatekeeper as these new developments are coming in. And hopefully you can issue spot at least with the developer and give them, the recommendations they need when they need legal, when they need accounting, when they need insurance, and when, of course, they need the manager expertise of setting those out. So you're going to help them follow some of those corporate formalities, those financial accounts that we've already talked about. And then, as I said before, don't get bullied by developers in pushing you to do things that are maybe outside of the role. So with that, I think I'll turn it over to Scott.
All right. Let's see if I can advance. Okay, there we go. So I'm going to go over just some sort of common issues that that we see, that I'm sure you guys have seen. These are usually issues, in my experience, that are often not noticed until after turnover. 3, 4, 5 years after turnover, we notice a problem that probably could have been resolved prior to turnover more easily. So first one is plat problems, and I've seen all too many times. So there's the simple plat problems, which I think are kind of the easier ones to deal with. Things like limited common areas designated wrong, or even common areas designated wrong. Those aren't, of course, ideal. I think we can go a long ways in the declaration to take care of those things. Although it's not, Utah law is not perfect on that. I don't really like how Utah law says that the plat and the declaration should be read in harmony. Doesn't give you which one controls over the other, because it doesn't give us a real clear answer in those situations, but it does give us some wiggle room, I think, to put some language in the declaration to try to make up for something in the plat that's a little bit wonky. To me, the more concerning problems, and this kind of plays into the annexation processes, is when a plat shows a lot that that for whatever reason wasn't actually made part of the HOA. It's not in the property description, or we didn't annex against it, and those sorts of things. Those are really problematic issues that are very difficult to resolve after the fact. A lot of times you're just left with going to the homeowner and saying, hey, do you want to voluntarily join the HOA? and by the way, you've been paying assessments that you weren't supposed to be paying. You know, those are problems we don't want to have to face. And if we can catch those before turnover, we're going to be much better off. And not just before turnover, but before the developer sells that lot. I think that as managers and attorneys work with developers, part of our responsibility is to do a lot of due diligence along the ways for these types of issues. You know, looking at, did we annex in every lot that needs to be annexed in so we don't have to deal with that headache down the road? Does the plat read really how we want it to read? Like Bert was mentioning, you know, did we put the right things in there? Does this common area look the way we want it to look? I've seen plat notes that kind of throw a wrench in the works, and so sometimes we need to be careful, read those plat notes to make sure they didn't say something in them that kind of hurts what we're trying to do with the HOA. Because these things.
Hey, Scott?
Yeah.
One little thing I just thought on the annexation process, because I think all of us attorneys and probably a lot of managers have seen issues with that. And so while this isn't always practical because the developer doesn't always know, when a developer does know the full development of phases that will come in, sometimes if they'll describe that whole development right in the initial one, and then sometimes if they set it up correctly, even if they miss maybe a supplemental declaration, it can protect them. I get it. That's sometimes they don't know where it's going to expand, but when they do, they can kind of think of that in advance.
Right. Yeah, I agree with that. I think the kind of big picture takeaway on both plat problems and annexation issues are that these are issues that are much easier to take care of if we can do it before turnover. And with the plat, some of that's just practical. You know, if you talk to an HOA board about amending the plat, a lot of times it's like, well, where do we even start? Does anybody know an engineer you can call or whatever? But with a developer, they're creating plats all the time, and a lot of times they have someone in-house, and so amending a plat really isn't going to be that difficult usually with the developer. And then especially when we consider the voting issue, and if they own the lots, then it's that much easier to amend the plat. So I would try to catch those things early on. The other issue that I would mention with annexation that I've seen, and probably some of you on the call have seen, is sometimes when a developer goes to annex in properties, they'll do something that actually, instead of annexing it into all one HOA, they create a bunch of separate HOAs, and sometimes inadvertently. So rather than doing like an annexation document or a supplementary declaration, they do just actually a new declaration against each phase when they didn't intend to have a different HOA for each phase. So that's something else to watch out for. And then, again, that's difficult to correct, not impossible, but it's going to take voting, and it's going to take everybody, and it's going to be expensive to combine all those HOAs into one. So making sure that's done correctly, I think, is some diligence that we could offer a lot of value on in the industry. And then the master association, sub-association issue, I've actually dealing just recently with a developer who his kind of overall plan for the community that he's developing has changed a number of times over the last couple of years, and I've sort of proposed to him, or several months ago proposed to him, hey, I think you're gonna have to do a master sub situation. And he's pushed back a few times. Why do we really need to create extra associations? But often, and like Bert said, sometimes maybe the smaller developers who are less sophisticated and haven't done a lot of kind of bigger communities won't understand that, and we need to explain to them that there are a lot of really good reasons for creating a master association. Sometimes, if you have a mixed use development, I don't know if anyone else has seen this. I've dealt with at least one development that I can think of a couple actually, that they had townhomes and detached properties in the same association, and so then that means that within the declaration we had to have lots of parts where we have this provision applies to townhomes, this provision applies to detached properties, and it gets a little bit messy, and it's usually a lot easier just to set up a sub master situation if the developer would do that at the beginning. And then there's also just practical things like if there's roads that the associations are going to share, rather than having easement agreements that you need to record and work out, then a master sub situation is just going to be easier. And sometimes you have to have that conversation with the developer because they might not be thinking of that. And then the voting classes, I just wanted to put that on there to say that I've also seen and dealt with, in fact, another kind of war story, dealt with a developer not too long ago who setting up one of his associations, and he kind of explained to me who the declarant was and who owned the properties and that sort of thing. But as I started drafting and researching the properties, it turned out that he actually had two different entities, and related entities owns both of them, but two different entities that own the lots. One owned about a third of the lots, another entity owned about 2/3 of the lots. And if we weren't careful, we could have given special voting rights to just one of those entities. And then if he sells off those lots and the other entity ends up owning the rest of the lots, then he loses those voting rights. So we need to be careful and make sure that, it's not uncommon for a developer in a big development to have maybe more than one entity that kind of has a hand in that development, maybe a different entity for each phase, or one entity for the master, different entity for subs, or those sorts of things. We need to make sure that if they're using more than one entity, that we're also accounting for that in how we set up our voting classes and declarant rights, and making sure that the right declarant rights are going to the right entities, and in a lot of cases are going to all of their entities and sub-entities, that sort of thing. There we go. So a couple of these others, commencements of assessments, unconstructed units are assessed under the law now in Utah unless we exempt them. So we want to make sure that you are specifically exempting them if that's the plan. For the developer, you want to make sure that's in the documents. And just be aware, I think that we know in the industry that there are certain things that don't apply to a declarant controlled community, but make sure that you're being aware of whether you have to actually state that doesn't apply, because sometimes that's the case, like as with the rulemaking procedures. It doesn't apply to declarants if the documents say so. If the documents don't say so, that's not an automatic exemption from that statute, and there's others like that. There's an interesting statute as well, and frankly, I'm not positive it applies to condominiums. I'd have to double check on that, but I know it applies to PUDs. Regarding contracts entered by the declarant, and it says that really what it suggests is that a contract entered into by the declarant is not necessarily binding after turnover, but there's some exceptions for that. And I quoted the language there. A contract that requires an investment of infrastructure or capital does continue on, but the way the statute reads suggests that other types of contracts don't necessarily automatically continue on, or the board has some kind of right to terminate them. The question there that brings up to me is whether there'd be some liability to the developer if they enter a contract that by its terms is going to go beyond turnover, and then now this vendor who relied on that gets a contract terminated, and the law says that the board can do it. The vendor probably is going to have a beef with that, and so I think that's something that we need to make sure that our contracts prior to turnover, at the very least, are putting the vendors on notice, or probably best case is to not have a term that goes beyond turnover, but at least puts them on notice of that there's this possibility under Utah law that the board might not continue it after turnover.
Yeah, Scott, and I'll bet you very few times are we doing that, right, as a developer putting on notice. And then the other little thing I thought about as you were going through that is how often a developer will very carefully, set out all the rights that they want within the declaration, and then the property is actually owned by a different entity. That they sometimes miss those connections of, if they're big, which entity does which, and they don't actually pass any of those declarant rights on to the correct entity.
Yeah. I want to go over some risk management strategies, and like Bert mentioned, this isn't really like a construction defect type seminar. That's not really the purpose here, but I think that managing liability for the declarant actually has benefits for the entire association, because a lot of times liability to the declarant can sometimes bleed over into problems for the association. So we've all seen some of these common provisions that are in declarations, and they seem to be more and more common in more modern declarations. Things like a buyback option that says that, if you have a claim against the developer, then the developer has an option to buy that property as sort of settlement of that claim. And there's usually kind of lots of hoops to jump through, but that's one common one. An overall just sort of waiver of claims, where the governing documents kind of say, hey, homeowner, you're waiving claims against the developer, maybe under certain conditions. And then another common one is minimizing the statute of repose. meaning that it says the governing documents, and I see this quite a bit in Rep Cs now too, that say that you can only sue you only have 1 year or 2 years or something to sue the developer after you buy the home. Those are sort of the common ones, and the restrictions on amendments, and that's a really common one as well. You can't amend this or that section without the developer's approval. I want to hit on though a couple of things to be aware of. I think if the developer's documents have that, and maybe some things you can sort of help guide the developer through, and maybe sometimes talk them off of the ledge of going too far with those things. So first of all, when we're minimizing the statute of repose, and we're saying you only have a limited amount of time to sue the developer that's less than what state law automatically provides for, our law allows the developer to do that, and it specifically provides that that our statute of repose provisions aren't intended to prevent a developer from contracting a shorter statute of repose. And if you're not familiar with the term, a statute of repose is basically a statute of limitations, but stricter. But the thing to be careful of though is that if you limit that to, let's say you limit it really low down to 1 year, and most likely if a homeowner has a problem that they want to sue the developer over, they're not going to discover it in the first month of living in the home. So let's say they're in the home for 9 or 10 months before they discover a problem, and they say, well, I'm going to sue my developer or my builder over it. Well, if that a period of time they have to sue is only 1 year, they sue on month 10 or 11, then by the time the builder gets that lawsuit and figures out who they want to sue in return, or who really is actually responsible for the problem, they're probably going to run out of time to pass that claim on. And so by limiting what the homeowner can do against the developer is also limiting themselves on what they can do against parties kind of down the chain. And so that could be problematic, and that could also mean that the problem doesn't really get solved. And so I think it kind of becomes everybody's problem. The other issue, this is just sort of an overarching concern that I have when I see provisions that go too far in being developer friendly in the CC&Rs, is I'm concerned that it might implicate what's called the implied covenant of good faith and fair dealing. So under contract law, there's this idea that every contract, and in Utah it's very clear that CC&Rs are considered a contract, or treated like a contract. So in every contract, the concept is every contract has what's called an implied covenant of good faith and fair dealing. So it's an implied covenant. It doesn't have to say anything about it in the contract. There's just the sort of implication that the law recognizes that the parties are going to treat each other fairly and are acting in good faith. We have some case law in Utah that described it, and I quoted it here. I'm going to go ahead and read this. As contracting parties, this is what the court said: contracting parties must refrain from actions that will intentionally destroy or injure the other party's right to receive the fruits of the contract. I'm afraid, and I haven't seen this, but I think we certainly could. And these really friendly developer provisions are, I'd say, relatively new, or at least much more common now than they used to be. So I don't think we've seen all the litigation that might come from them. I'm concerned that if you go too far, then somebody might have a good claim that says, by having that provision in there, they've really stripped away my rights as a homeowner to fully realize the benefits of these CC&Rs. I can't actually recover what would be fair for me to recover, and that's a breach of the implied covenant of good faith and fair dealing. I think that could be a good argument in some cases. And so I think that it's going to be in everybody's interest to make sure that those developer provisions, while we totally understand why they're in there, to make sure that they're reasonable. If you read it and it just feels totally unreasonable, then it might be unreasonable, and it might not kind of pass that test if there is that sort of challenge. Sorry, trying to advance to the next one. There we go. Okay, so there are some defined duties that a developer has, that a declarant has towards the community, and these are important when we're working with developers. It's important that they understand what these duties are, and Bert kind of touched on this, that it's kind of a tricky line to walk, where a developer, on one hand, they are acting as the developers trying to sell homes, and that's their livelihood, but they also are acting as an agent for an association, and they do have some legal obligations towards that association, and there's some conflict there. And the court has recognized that. And in the Davenport case, the court articulated that and said, so, here's what we think those duties specifically are that a developer owes to a community. So to use reasonable care and prudence in managing and maintaining the common property. I've highlighted this next one because it's one that I think is one of the most common issues that developers get dinged with, or at least complained against about. Establish a sound fiscal basis for the association by imposing and collecting assessments and establishing reserves for the maintenance and replacement of the common property. We all know that it's pretty common for a developer to set assessments as low as they can sort of get away with, and sometimes they're artificially low because it's easier to sell homes in a community where you can say, hey, the assessments aren't very high here. But the issue there is that if at turnover there's just not enough funds to actually take care of the things that need to be taken care of for the association, then the developer has breached their fiduciary duty to the association by not establishing a sound fiscal basis. So something that the developers need to be aware of, and they don't often want to hear, but it's one that the law is clear that they have a duty to the association regarding. Some other things, they have to disclose the amount by which they're subsidizing services, and that's not uncommon where developers just sort of taking care of this service or that service with their own people, or the association not being charged for it. It's important that the association know that upon turnover, that there's some expenses that might not have shown up in your budget that you're going to have to take over once the developer is no longer in the picture. Yeah.
Just on that one, I was just going to note that I've actually some big sophisticated developers that still, because on one hand you think, well, this is crazy. I'm writing a check to the association, right, to take care of something, and they don't understand, right, these duties, and that down the road the issues that causes, as you noted, with then needing to raise assessments. And so it's one I know that's been out there, but it's still one where I see pretty sophisticated developers saying, well, why would it be bad that I'm writing a check to the HOA?
Right. And kind of along those lines, sometimes what we see is at turnover, they'll just write a big check to say, well, we're going to put some more money in your coffers, which isn't always maybe it's almost never a bad idea. And sometimes that can help if they've been charging assessments that are too low, and then they're budgeting out and saying, well, here's what the association is going to need. Then maybe sometimes that almost requires them to just put a lump sum into the accounts before turnover. I think it can help at least against that problem and that liability. Another one that I've highlighted that I at least have seen a lot of problems with is that the developer is obligated to comply with and enforce the terms of the governing documents, including design controls, land use restrictions, payment of assessments. Again, developers don't always like to do that. They don't always like to strictly enforce the governing documents because they want a community that's easy to live in and easy to sell homes in. But that is probably many of you have seen can cause problems. I've too many times, worked with a community where there's some relic of the developer's exceptions that they granted to all these people, for fencing or roofs or whatever, where the governing documents say you can't have this or that material, and the developer said, well, to this homeowner that they could have it, and to that homeowner they could have it, and then you kind of have this checkerboard of non-compliance. And then it's really hard for the association to then come in and say, well, we're going to start being strict about that, even though we know some of these properties were built in a way that's non-compliant. That really comes back to the developer because they had a duty to not do that. And so that's something else that I think is important for the developer to understand, that if there's architectural controls that are in the CC&Rs, they've got to make sure they're complied with. And then the last two are disclosed material facts and circumstances that affect the condition of the property that the association is responsible for maintaining, and disclose material facts and circumstances affecting the financial condition of the association. And then this is similar to what we're talking about, including the interest of the developer and the developer's affiliates in any contract, lease, or other agreements. Some of that comes to turnover, and we'll talk about this in just a second. But at the turnover meeting, I certainly recommend that kind of doing your preparation before the turnover meeting to go back and revisit the Davenport duties and make sure that these things that Davenport says are supposed to be disclosed were disclosed prior to turnover or are disclosed at turnover. I'll touch on reserve studies. Bert talked about this a little bit, and some of my comments are the same as his. We all know what a reserve study is, And technically under the law, literally the way that the law is written, the declarant is exempt from the reserve study statutes. They don't have to have a reserve study every 6 years and an update every 3 years. But practically speaking, I agree with what Bert said, that I don't know that that works well kind of in the real world, because if the developer has a duty to make sure there's a sound fiscal basis, which was one of the Davenport duties that I'd highlighted, then how do you do that without having some kind of diligence on some kind of research on what is going to be required for this community over the next 30 years or whatever? What are those major components and how do we fund them? Maybe it's not a formal reserve study, but I think that a formal reserve study is probably the best way to do that. And certainly when it comes to the developer protecting their own interest, if they have a formal reserve study, and especially if it was from a third party and they fund it according to that, then it helps them and it helps the community. So even though a reserve study is not technically required, I think that it's a very good idea, and it's I won't go so far to say that it's required in practicality, but almost. Some kind of budgeting tool I think is going to be required for them to really be able to meet that duty. Duty to preserve and maintain common property is another one that's clear. That's a developer obligation, and I just have one comment on that. That sometimes you'll see in the governing documents some specific duties, like the developer will have this many trees per lot or that sort of thing, and that's interesting when you see those kind of provisions in the documents, because then I think we've even kind of stepped out of fiduciary duties and into sort of like a contractual obligation the developer has now created with the HOA. So I think they at least need to be aware that you have now some kind of contractual obligations that are probably legally enforceable. And then this is the last slide, and I think that everybody on the call kind of understands turnover and how turnover works. So I lost my train of thought. I had one comment that I was going to make. Oh, I know what it was. One issue that I will say that I'd make sure to do as part of your diligence before turnover is making sure that if there are any common area lots that show up on public records as owned by the developer, and sometimes that's the case. It's case by case, and it depends on sort of how the county set up its records. Sometimes your common area lots will just show as common area lots. Sometimes they'll actually show as they're assigned a parcel and they're owned by somebody. And I've seen it pretty frequently where those lots are not actually turned over, that it shows on county records that they're owned by the developer or by the declarant entity, and they're never deeded over to the HOA, and that can cause problems. And just sort of practically speaking, one of the biggest problems that I'm dealing with right now and I've dealt with before is property tax issues. The county, I'm dealing with one right now where the lots, now as I read the statute, what I think the county is supposed to do is they're supposed to rely on the subdivision plat. And if the subdivision plat shows it as common area, they're not supposed to tax it individually. They're supposed to spread that taxation among the lots, even in a non-condo association, which where common area is treated differently. But that's not always what the counties do. The counties usually rely just on sort of what their own parcel map shows. And if the parcel map shows that it's individually owned, then a lot of times they're gonna charge property taxes against it. And I'm dealing with one right now where they've been charging those property taxes to the developer. We're about a year past turnover, and the developer is going, well, I don't really care if that's paid. It's not my problem anymore. And we're about to go to tax sale, and the county won't take payment from the HOA because the HOA is not the owner of record. And so then it's a mess that we have to deal with. And there are other issues that I think that could create. And so I think that's part of the diligence, is looking how common area shows up on the parcel records of the county. And if there are parcels that we know are common area that are deeded specifically to the declarant, then make sure those get deeded over to the HOA prior to turnover. Whoops. And that's the last one. We left about 10 minutes here for, I don't know if you have other comments. We left a little bit of time here for some Q&A too, if we have any.
Yeah, I was hoping we'd maybe get a few questions, and so we had planned to leave a couple minutes. I think we might have one. I'll let Andrew jump in here.
So the first question is, where is the legal authority that the articles of incorporation trump the bylaws?
So that's in both it's in both the Community Association Act and Condo Act. I don't know if Scott knows the citation off the top of his head.
Yeah, I don't know the exact citation off the top of my head. There's a provision in each act that kind of says here's the order of governing documents. I could take a second and look.
I believe it's 40 in the Condo Act.
And that was revised a few years ago.
One interesting thing I've run in that same statute talks about how the Community Association Act and Condo Act trump over the Nonprofit Act as well as in there. But I know in working with the state, they don't care. Whenever we've tried to say, hey, we can do this, it specifically says we trump over, whatever may be a conflicting internal requirement that you have in there. But I don't know if anyone else had any luck. We haven't had any luck with that.
Huh. Yeah, so you're right, Andrew. 57840 is the one in the condo, and it's a little bit tricky because it doesn't specifically say articles of incorporation. It says a document, an organizational document filed in accordance with, and then it cites the Nonprofit Act. And if you follow that through, then we're talking about articles of incorporation, and it says that they control over the following documents below, and one of those documents is the bylaws.
Okay. The next question is, after an owner purchases a condo, which includes ownership of an undivided interest in the common areas, is it appropriate or proper for the HOA to require owners to sign a waiver against any lawsuits?
So I assume the question is about signing a waiver against lawsuits, or signing a waiver so they won't sue the developer.
I think, Scott, it probably kind of illustrates that point that you were talking about, right? First, there's maybe some applicable, statutes in the whole construction defect issue, but you can put anything in a contract, I guess, right? And I think a question of the good faith of what you're talking about, and I kind of agree. I see maybe that line getting pushed more, and maybe at some point it'll get pushed over the hill where someone says, you can't sue anybody for anything ever, go away, and maybe that's where we're going here.
So it's not the developer that the waivers would be; it would be against the HOA and ongoing management.
Oh,
Is that appropriate?
So just a waiver to ever bring a claim against the HOA.
Yeah.
Huh. Yeah, so it depends what hat you're wearing, right? But I guess you're asking what's in the best interest of the HOA, and to me that's an interesting question, because sure, it's in the interest of the HOA to not be sued, but to the extent that the HOA has duties to the members, is that really the best interest of the HOA to not allow for any resolution of those kind of problems? I don't know. That's a question that I think we could kind of nerd out about, but never come to a real answer on.
Yeah, I wonder if it's, and I get that question sometimes in the context specifically, and I know others, and I know there's counterpoints to this argument as well, but the records request statutes in Utah, and how some describe those as being weaponized by owners. And I've certainly got that question from associations when they've spent thousands and thousands, right, of responding to records requests that never end. And maybe it's in that context. So there'll probably be some continual push and pull, right, of association board rights versus owner rights, and maybe we'll see more of that get fleshed out in the Utah acts. Yeah,
I would really question. If it's really just a totally broad, you can never sue us for anything ever, I would question whether that's even going to be enforceable anyway.
I agree.
Okay, that's all the questions that have been posted. Any parting thoughts?
Okay.
Hey, there's nothing wrong with being done 5 minutes early on a Friday morning and letting people get on with their stuff. So I appreciate the opportunity to chat here, and appreciate Scott and his preparation as well.
Yeah, thanks everyone. Thanks for taking some time to listen.
So,
Bert. Let's
hey,
finish early rather than late.
Really quick, one other question. So, in that waiver context, what if it's to do with the use of the pool or clubhouse? Can you sign a waiver of liability for use of a common amenity, I guess? Is that appropriate? Not to sue the association.
I've seen that, particularly in the context of COVID, Scott. Maybe you've seen the same thing where boards, in the height of that, were trying to balance the homeowners that wanted access to the amenities versus, the homeowners that wanted to reduce liability for the association. Regardless of whether it's an HOA context or other, I personally never think those waivers are quite the silver bullet that we think they are, that people think they are. I think we still need to act, reasonably in the best interest. But I've certainly seen them used in that context.
Yeah, and I hate to give kind of an evasive answer, but the reality, and every attorney that was just in law school, is that the hypotheticals are difficult because things always change on individual circumstances. And I think the reality is that it's case by case. There might be details in some situations that would make that appropriate. There in other situations it just might not be. But I think the my underlying thought on it would be the same as Bert's, that it might not do what we think it's going to do anyway. Then they're not always enforceable just because it's in writing and signed.
Okay. All right. Okay, I guess we'll wrap it up then.
Okay, thank you.
All right, thank you everyone for joining. Thank you, Bert, and thank you, Scott, and thank you again, Andrew. And I see we do have one more question, is how can we get slides and the recording of the presentation? So that will be available, the presentation slides, along with handouts from our two platinum sponsors, Century West and Candace Brewster Insurance, will be available in your email inbox later today. And then, of course, the copy of the recording of the webinar is available on our website once that gets posted under our resources tab on our webinar library. So thank you all for joining us, and have a great day. Thanks.
Thank you.